Welcome everyone to this new episode of the Privacyrules Privacy Espresso series of short videos where we interview our experts and guests from all over the world on the most recent news on privacy and data protection. Today I'm joined by Minhye Kim from the law firm Dlight Legal from South Korea, because we are going to receive some updates. There has been some extensive amendments on the Personal Information Protection Act in Korea. So first of all, I would like to thank Minhye for being with us. My first question to you, briefly explain us the purpose of those extending amendments that we were mentioning.
So, current incident about revision of Personal Information Protection Act is a big issue in Korea as well, because the amendment was made and it will take force in September this year. And following amendment is also made for the presidential decree. So let me get started from overviewing the purposes of the amendment. In the time of the fourth industrial revolution, fostering new industries through the vitalization of data is emerging as a national task. We're witnessing a growing need for our nation to create new business sectors by actively utilizing data. However, under the current law, the function of personal information protection supervision has limitations in supporting the vitalization of data use to spur growth in these new industries. To overcome these hurdles, South Korea is setting up a system that allows the use of pseudonymized or disguised data. This data can be employed for scientific research, creating statistics, and maintaining records for public good. Without requiring approval from the individuals, the data is about to maintain a balance. South Korea is implementing measures to better protect personal information. This includes holding those who control personal data more accountable. The Personal Information Protection Commission, which oversees any misuse or leaks of personal data, will have its powers strengthened to do so. And as I mentioned before, the amendment will take force in September 2023 this year.
Thanks a lot for this brief introduction to the topic. And you were speaking about an industry that is related to technology and these changes. How does those changes and in general the Personal Information Protection Act support the fostering of this fourth industry and privacy and data protection at the same time? So how are you merging those two topics together?
Well, the amended act revised the regulations for fixed image information processing devices, installation and operation of fixed-type video information processing equipment in public places is permitted in cases where recorded video information is not stored and is determined by presidential decree. In addition, in the case of facility safety, fire prevention, and traffic control, which were previously allowed, it was specified that they should be installed and operated by a person with legitimate authority. Furthermore, the revised law introduced regulations for mobile image information processing devices, such as drones, in addition to the current law, which only regulates fixed-type image information processing devices. According to the current Personal Information Protection Act, there are significant restrictions on filming using drones, self-driving cars, etc. The amended law is significant in that it has resolved this problem. Mobile image processing devices are newly defined, along with mobile image processing devices that collect personal information. Under the amended Personal Information Protection Act, filming using drones, self-driving cars, etc. is allowed under specific operating standards. In particular, under the amended act, the fact of filming is clearly indicated so that the data subject can be aware that personal information can be captured through a mobile image processing device. However, since only photographing is allowed under the revised law, other legal grounds such as the consent of the information subject must be in place for additional processing such as use or provision of personal information. Secondly, the amended act established the basis for the introduction of the general my data industry and artificial intelligence and give data subject more control over their personal information. The amended act introduced the information subject's right to request transmission of personal information, the right to reject automated decisions, and the right to request explanations. According to the amended law, information subjects can request the personal information controller to transmit their personal information to themselves or to institutions specializing in personal information management and those who have met the safety standard prescribed by the presidential decree. Personal information that the information subject can request for transmission is limited to personal information processed by information information processing devices, and information which personal information controller generated itself by analyzing and processing collected information is excluded from the subject right to request transmission. The personal information controller who receives a request for transmission is obligated to transmit the information within a reasonable range permitted by time, cost, and technology, and may reject the request for transmission or suspend transmission if the identity of the information subject cannot be verified. The amended Personal Information Protection Act also introduces the right to reject automated decisions and the right to request explanations as one of the rights of data subject. If the personal information controller makes an automated decision, the data subject may request an explanation of the decision. A data subject may also refuse the decision of processing personal information made with a fully automated system, such as a system applied with artificial intelligence technology, if it has a significant impact on his or her rights or obligation. In this case, the personal information controller shall not apply an automated decision and should reprocess or explain with human intervention. The right to request data transfer and the rights regarding automated decisions were previously included only in Credit Information Act. Through this revision, the scope of application has been expanded to general personal information. This expansion of the scope of application is to protect the personal information of the information subject, in line with the reality that the scope of artificial intelligence technology is expanding.
Perfect, thanks a lot. That sounds very interesting, and we understand that in South Korea there is a very structured and complex framework to be respected that makes it not surprising that South Korea is one of those countries deemed adequate by the EU, or one of those countries where data transfer is easier for us on the EU side of the world. You were also mentioning about some other major revisions while we were speaking. May I ask you what are those other major revisions about?
First, when collecting and using personal information, the requirement for legal grounds is eased. Under the current Personal Information Protection Act, the consent of the information subject is strongly required for the collection and use of personal information. The collection and use of personal information is strictly restricted without the consent of the information subject. However, the revised law has deleted the requirement inevitably from inevitably necessary for the conclusion and execution of a contract with the information subject, which was stipulated as one of the exceptions for the collection or use of personal information without the consent of the information subject. In addition, among the exceptions that allow the use and provision of personal information for other purposes without the consent of the information subject, the requirement of when consent cannot be obtained has been deleted from when the consent of the information subject or her legal representative cannot be obtained, and it is clearly necessary for the interest of life, body, or property. This change is expected to expand the scope of use of personal information for contract fulfillment and to expand protections of the right and interest of information subject in an emergency situation. In addition, as the international transfer of personal data becomes more common, the Act is revised to allow more instances where personal data can be sent abroad. This is to keep up with international standards. Cases in which additional overseas transfer is allowed include cases in which there are provisions or international transfer of personal information in laws, treaties, or other international agreements, or cases in which transfer is necessary for the conclusion and execution of contract with data subject. However, on the other side, the amended Act allows the Personal Information Protection Commission to order the Personal Information Controller to suspend overseas transfer of personal information. And finally, the revised Act applies the same regulations for online and offline businesses to avoid unnecessary confusion due to different rules. The current law stipulates as a special provision the personal information protection related regulations that apply to online businesses, which were previously regulated in the Information and Communications Network Act. The revised law has converted many of the special provisions for business into regular general regulations that apply to both online and offline personal information processors. I think that's the most of it.
Once more, it's clear that South Korea is definitely a country that is investing in finding solutions and being up to date on those relevant topics. So, Minhye, thanks a lot for being with us. And I would like also to thank our audience for being with us. So thanks a lot.